Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. As always, guys, I do this to help other people with foreclosures. I am not an attorney and I cannot give legal advice. This is just for entertainment purposes only. So if you have a question, you might want to contact an attorney if it's about a foreclosure. Otherwise, if you have a question about any of my cases or my videos, you can send me an email to foreclosurehelp777@gmail.com and I'll try to answer your question. Today we're going to give an update on a couple of people's cases that are going on. We're going to look at Marlon Lewis's case first here. Let's see here. And he is in Texas. And this is his eviction case, which he removed to federal court. And it's in Houston, and the case number, in case you want to follow it on Pacer, is 425CV01490. Marlon Lewis versus U.S. Bank. Well, it's actually plaintiff U.S. Bank for the Igloo Series 4 trust, which we know is a fake trust. Defendant Marlon Lewis. And this case was removed from the eviction court to federal court on April 1st, as you can see right here. The other side tried to remand it. It got stricken. As you can see here, motion to remand on 4-3. An order striking it because they didn't follow procedure. And then they had a hearing on this. And basically, the judge told them that they have so many days to file a proper motion to remand it back. And then what happened was Marlon filed a opposition to their motion to remand on 5/7, which was just yesterday. Okay, so he is opposing their motion to remand. So let's take a look at what that looks like. Opposition to motion to remand. As you can see, this is the heading here. And that's a case number there. Defendant's opposition to plaintiff's motion to remand. Comes now defendant Marlon Lewis Sr. appearing pro se and respectfully submits his opposition to plaintiff's motion to remand. Would show the court the following. Introduction. And guys, you have to make sure your motions are formatted properly. And in this case, this is Arial 12, and the headings are Arial 14, in case you're wondering, and they're double-spaced. This case is not a simple eviction. It is part of a broader and ongoing dispute over the validity of title, the lawfulness of the foreclosure, and whether plaintiff has authority to initiate eviction at all. These issues directly overlap with those already pending before this court in case number, and then there's the other case, 424CV02727. This motion to remand must be denied because the court has subject matter jurisdiction under both 28 U.S.C. 1331, which is federal question, and 28 U.S.C. 1332, which is diversity. And judicial economy strongly favors retaining this matter in federal court. Argument. This court has jurisdiction based on the federal questions already pending. Defendant removed this matter under 28 U.S.C. 1441 because the eviction proceeding is inextricably linked to a live federal case, with the 2727 case, already pending before this court. That action includes causes of action under the Bankruptcy Code for violations of the automatic stay and improper application of Chapter 13 payments, the Real Estate Settlement Procedures Act, or RESPA, breach of contract, and wrongful foreclosure under federal and state law. Now, the Bankruptcy Code situation, they didn't violate the automatic stay. That was put in there because they did not properly apply the payments. His Chapter 13 payments were not properly applied. So the automatic stay shouldn't have actually been in there, but oh well, it's in there now. The plaintiff's attempt to isolate this action as a mere eviction ignores that plaintiff's alleged right to possession arises from a disputed foreclosure, a foreclosure that is the subject of detailed federal claims currently before this court. Federal courts routinely find supplemental jurisdiction over possession issues where the legitimacy of the title transfer is contested under federal law. Okay. Diversity jurisdiction exists. Even apart from federal question jurisdiction, diversity jurisdiction applies. The parties are diverse. Plaintiff is a citizen of another state, a national trust, domiciled outside Texas, while defendant resides in Texas. Contrary to plaintiff's argument, the amount in controversy includes the value of the right to possess the property, which exceeds $75,000, particularly where the property value and injunctive relief is implicated. The fair market value of the property to determine the amount in controversy. As the Texas courts have recognized, a justice court has no jurisdiction over a forcible detainer where the right to immediate possession is not clear and depends upon resolution of the title dispute. In Armstrong versus Mitchell, the court held, if the question of title is so intertwined with the issue of possession that the possession cannot be determined without first determining title, then the justice court has no jurisdiction to enter a judgment for possession. That is precisely the case here. The plaintiff's right to evict defendant turns entirely on whether plaintiff lawfully obtained title through a foreclosure sale that is actively being challenged in a pending quiet title action in this court. As such, remanding the eviction to justice court would be improper, and that court lacks authority to resolve the underlying title dispute that is essential to determining possession. Justice court jurisdiction is not exclusive when title is at issue. Texas law does indeed assign original jurisdiction over evictions to justice courts, but only where the right to possession is uncontested. Whereas here, title is in dispute. The justice court's jurisdiction is not exclusive and may even be defective. And then there's case law here, Rice versus Penny, which held that justice court has no jurisdiction to determine title disputes, and Dormady versus De Niro Land and Cattle, justice court cannot determine possession when there is a genuine title dispute. Because federal case includes a claim challenging the foreclosure and loose pendants have been filed, the dispute is fundamentally about whether plaintiff validly acquired title at all, not just possession. Plaintiff invokes Article 1, Section 29 of the Texas Constitution, which expressly voids any statute or government action contrary to the constitutional protections of due process and property rights. As the substitute trustee's deed was issued without verifying authority or lawful contract, and while this pendants was recorded, all subsequent attempts to seize or evict are unconstitutional, null and void. Judicial economy and the pending motion to consolidate. The motion to consolidate, case number 01490, with the pending title dispute, which is the 02727, is currently before this court. Judicial economy favors keeping this case where the full context can be evaluated. Piecemeal litigation risks conflicting outcomes. Wrong party brought eviction, misjoiner. The entity initiating the eviction is Igloo Series 4 Trust, but the substitute trustee's deed names Igloo Series 5 Trust. No recorded transfer or assignment has been provided showing that the 4 Trust has any interest or standing to bring that action. This constitutes a fatal defect under Texas Rule of Civil Procedure 17 and applicable Texas case law requiring a remand to be denied and the defective party dismissed. See Steed versus HB1 Alt Holdings. Okay, constitutional due process violation. Under Article 1, Section 29 of the the Texas Constitution, all rights secured by the Bill of Rights are inviolate, and all laws contrary to them are void. The non-judicial foreclosure deprive the plaintiff of property without a full hearing, judicial oversight, or verified evidence of standing or ownership. This triggers 42 U.S.C. 1983 and other federal protections, which must be reviewed by this court under its original jurisdiction. Remand would result in further deprivation of constitutional rights contrary to state and federal protections. Loose pendants render subsequent title transfer subject to litigation. A loose pendants was recorded prior to the foreclosure sale. Under Texas Property Code 13004, this constitutes notice to all parties of ongoing litigation concerning the property. Accordingly, any title transfer that occurred during the pendency of that litigation is subject to its outcome. The plaintiff, as transferee, acquired no superior claim to possession while the quiet title action is pending. Prayer for relief. For the reasons stated above, this court retains jurisdiction over the matter under 28 U.S.C. 1331 and 1332. Because the eviction is directly connected to pending federal litigation, involves fundamental title and constitutional issues, remand would be improper. Defendant respectfully requests that this court deny plaintiff's motion to remand and grant all further relief as just and proper. Okay, so that's pretty much how he argued his case here. And you can see this was just filed yesterday, and he does have another case, his main federal case, which if you click on that, you can actually see his case status here. Take a look real quick. Okay. So the last thing he filed, and we went over this before, was a judicial notice about the procedural history of the motion to dismiss, which basically states this. If they file a motion to dismiss after they file an answer, that's improper. They should not be allowed to file a motion to dismiss after they file an answer. So that's what they did. So we'll see what happens with his case. Another person that is also fighting foreclosure, we can look at Rachel Tennyson's case. She's North Texas in her case. And hers is Tennyson versus Loan Care LLC, and her case number is 325CV00661. She filed her complaint on 3/19/25, as you can see here. Then they filed a motion to dismiss. Let's see what happened here. They filed a motion to dismiss on 4/23/25. And so what she did was she filed an amended complaint, or leave to file an amended complaint on that, which was on 5/6, with a first amended complaint attached to it. And then the judge issued an order allowing her to have her amended complaint. So there it is on 5/8, amended complaint in the docket, which means the whole thing starts all over again, and then they have to file an answer to her amended complaint or a motion to dismiss her amended complaint. And this is just something people do to prolong the case for as long as possible. And we know that this works for a lot of people. So guys, if you have any questions about any of these cases, you can send me an email and I'll try to answer your questions. And I hope everyone has a blessed day.